Secretary to assist me by presenting Exhibit BB1, projecting it. I just ask you to scroll down for me, please. No, please scroll back up for me. Sorry. Not so fast. Sorry. Back down for me. Sorry. Sorry, not so fast. Down further. You just stop here for me. Sir John Swan, I'd asked you earlier, but just for clarity, I direct you to the document on screen, which is an exhibit BB1, and specifically ask again, but I ask just again with clarity now, whether or not you had been made aware that a caveat had been lodged with a view to challenging the estate of Mr. Edwards. Were you ever made aware of this fact?
No.
Could you scroll down for me, please? Scroll again, folks. All right, thank you. That's it. You could remove the document. I just asked you to take me to CNLB 18. Scroll down for me, please. In your evidence earlier this morning, Sir John Swan, you made mention of transactions between yourself and Mr. Leslie Earl Ming. Could you just remind me of what you had said in that statement earlier this morning?
I said Leslie Earl Ming was one of the people that we put the property, the lots, some of the lots into his name with the view to being able to borrow money as a mortgage from the bank or from any other source in order to build on the properties so that then we could then sell them to people who want to buy them.
At the time that this was done, was Leslie Earl Ming an employee of yours, or was
he was employed by me? Yes.
But in regard to this posture, you never put it in your own name.
Well, you see, the thing about those days, companies couldn't buy it on property for residential purposes. So it was and since we were building so many houses on the island throughout the whole island itself, And since we had to raise the money to take and do that in order to, and then finance them for people to buy them, we had worked out a method by which we would raise the money by way of a mortgage on the property and build on it and then resell it afterwards.
So at the end of the process, the property was transferred back to the company or to you, directly to you?
The property was then transferred to the new owner. Not back to me, but to the new owner.
Okay, why I asked, could I just ask you to look at number 8, item number 8, for instance? Could you just scroll, Secretariat? At item 8, it says Memorandum of Voluntary Conveyance, 13th December 70, Leslie Earl Ming to John William Swan. Book of Voluntary Conveyance is number 17, page 190, Lot 4, Sands Parish, 0168. So I asked the question in the context of this because before we go any further, this document received from the title's office speaks to a transaction here, but at item 8, it's Leslie Earl Ming to John William David Swan. That's why I asked the question earlier, was it being transferred to the company or you in your personal capacity?
In my personal name. Personal.
So not,
companies could not own real estate.
right. So that's what I was asking. So like in this instance, I haven't shown you the first part of this transaction, but what was being done was that you acquired a property, you then transferred it to Leslie Earl Ming, and then he transferred it back to you.
That's right.
And just by way of asking, why didn't you take out the loan in your name as against an employee? Who paid when the employee's name was put on it? You still paid it. Who paid for it?
I paid for it.
Okay, but you just put it in somebody else's name.
That's right, yes.
I have nothing further, Chairman.
Yes, Council, I hear that you've ended your question of Sir John Swan. I would ask at this time, and with your direction, Council, if anyone else, starting with Mr. Hanson, would like to question anything Sir John had said.
No questions from me to Sir John, Mr. Chairman.
I record that Mr. Hanson has no questions of Sir John. I'll ask Ms. Myra Virgil.
No questions from me, Mr. Chair.
Ms. Myra Virgil has no questions of Sir John. You record that. And Council, I now ask the Browns or the George or his brother if they wish.
Yeah,
to have any questions of Sir John.
we have no questions.
Council, we record that the Browns have no question of Sir John. And Council, I now request that you direct.
Mr. Chairman, I'm to be afforded the opportunity to redirect
action of this Commission of Inquiry at this point. Start with Mr. Starling.
I'm sorry, Mr. Chairman. Mr. White has some questions that you.
That was about he acted like the land.
Chairman.
Yes, I know. I wasn't hearing you clearly, but now I hear that Mr. White has some questions of his client, Mr. Swan.
These are questions that arose in the cross-examination by Mr. Harrison, and this wants to provide some clarity. It's called redirect. Mr. Chairman.
Yes, Mr. White, if you would carry on.
So, John, you recall at the beginning, Mr. Harrison was asking you about the conveyance JS1.
Yes.
Yes. And he was asking why the lawyer's name appeared there?
He did ask me why the lawyer's name appeared.
And is it not correct that that was the conveyancing practice then in Bermuda to have the lawyer's name on?
Absolutely. The lawyer, all the documents had the lawyer's name on them as the draftsman for it.
Thank you. So John, you recall Mr. Harrison taking you to the statement of Mr. Brown, Charles Brown, dated March 25th, 2021. Could the commission secretary put it up, please? And could you scroll down to number 6? Thank you for blowing it up. Yes. So that number 6 reads, Sir John, Russell Pierman, Emmanuel Augustus, and John Swan visited the property together just before Christmas in 1968. Russell, the seller, was acting as the agent for John Swan, and John Swan was acting as agent for Emmanuel Augustus, the purchaser. That's what it says. Let me ask you first, did Russell Pierman accompany you to that property with Mr. Augustus?
No.
Was Russell acting as agent for you?
No, absolutely not.
And were you acting as agent for Emmanuel Augustus?
I was acting as advisor to Emmanuel Augustus on the purchase of the property.
But not as his real estate agent?
Advisor for him to purchase, but not as a real estate agent.
Thank you. Could you scroll down, please, to the number 11? And you recall we talked about this in direct, but Mr. Harrison took you back to the police report. It's correct that police made that request in 1976 for the document, as it is not put there, but it was done in 1976. Do you recall the police report being in 1976?
I don't really recall that report, really.
Okay, all right, fine. I won't ask any more questions about that. But you are sure that you produced a conveyance in 1978, as the Browns have actually said in their testimony?
I produced a report in 1970.
No, a document, the conveyance in 1978. They reported that you did produce the conveyance that was being sought in 1978.
Oh, yes, I did produce that. Yes, I did.
Yeah, okay, thank you.
I'm sorry, just for clarity, Mr. Chairman, the last question from Mr. White indicates that the Brown said that something was presented in 1978. My memory doesn't take me that far back. I'm not saying that it wasn't said.
I'll assist you. I will assist you. I have a note of it somewhere here. It was in there. Let me see. It's in their part about. There was an acknowledgement in the papers that the report was produced by Sir John in 1978. And I'm just looking for where that said that.
Wasn't that in the police?
Yeah. In fact, maybe it's in page 55. Maybe the one. Yes, turn to page 55 of the Brown's bundle. I'll start reading it while you're finding it, Secretariat. Sergeant Casson reported that a search had been in progress for a number of months by John W. Swan Limited for the conveyance, at the bottom of the page. The conveyance dated 15th April 1969. There have been no success to date. A conveyance dated 1969 was produced by John W. Swan in 1978.
Okay, I
That's where the
stand, I
records
stand
come from.
corrected.
Thank you,
Okay.
Mr. Harrison. Now I've got my papers all in disorder, so I have no idea where I'm going. Just give me a moment, please. Okay, there we go. I have no further questions of Sir John.
I noted that Mr. Kimwhite has no further questions of his client, Sir John Swan. And now revert to counsel.
I have nothing, well, nothing that would allow me to say anything, but I think we would now move to the next
No, the commission.
person.
The commission. They may have
I'm
questions.
sorry, the commissioners. Commissioners may have questions.
I'm guided by you, Chair.
Yes, I'll start with you, Mr. Stabu. Do you have any questions of Sir John?
I do. Thank you. Good afternoon, Sir John.
Good afternoon.
I have a few questions. I'll try to be as succinct as possible. After you have listened to the testimony and evidence of the matter before us, do you acknowledge
Can you
that there
repeat
may
yourself?
have
I can't
been?
hear you. Can you repeat yourself? I can't hear you.
Okay. Does everybody else hear me?
Yes.
Okay. After you have listened to the testimony and evidence presented on this matter, do you acknowledge that there may have been some untoward activities with regard to the ownership of the subject property?
I don't have evidence to confirm or deny that there might have been.
No, I'm not asking you for evidence. I'm saying on the face of the testimony and evidence that has been presented in this forum, do you think it is reasonable to regard that there may have been some untoward activities in reference to the ownership?
All due respect, sir, you're asking me to sit in judgment on something that I don't have the evidence to sit in judgment with. All I'm hearing now is hearsay.
No, but this has been evidence. There have been experts that have testified. It's not hearsay.
Experts will have,
Testimony.
the judge or the adjudicators will have to decide whether they think it's valid. I am not prepared to validate it.
Okay, so, all right, we'll move to the next question because I'm just asking a common sense. In other words, if you've received further information which you have testified thus far that you hadn't heard previously, then perhaps that may cause you to adjust your initial outlook. But I move on to the next question.
I'm glad you used the word may, and I refer back to the word may. It may or may not, and I'm not satisfied.
Well, that's all I'm asking, Sir John.
Okay.
I'm not asking for a conclusion.
I've given you my answer.
Okay. Would it be fair to say that this matter has not been heard and presented before the courts?
I appeared before the courts.
No, that's not what I'm saying. I'm saying, would it be fair to say that the matter has not been presented and heard before the courts?
Which matter are you talking about?
The matter that's before us now,
With
regard to the legitimate ownership of the subject property.
The matter did appear before the courts. I accused of having acquired a property that I was not supposed to have been able to acquire. That matter was dealt with by the justices on 6 different occasions, of which it was dismissed. I could only go by what the justices would have dealt with in their adjudication and determination. That's all I can go by. I'm not a lawyer. I'm not the court, and I had to listen to what the justices did, and what they required was their discretion.
Okay, let me be more specific to that. From the testimony that I believe we've heard,
But
and
testimony
even
from whom? Testimony from whom, sir?
if you let me finish,
Okay.
just for in the interest of better understanding and clarity. I believe we've heard perhaps from your counsel and also the Browns that effectively the matters were not tried and argued in court, but for various reasons was struck out prior to the cases being put before the court.
I don't have a legal background strong enough to determine what was and what wasn't. All I did is listen to the conclusion of the judges.
Okay, so in getting back to my initial question, would it be fair to say that this case, as presented by the Brown family, has not been heard before the court?
This case presented by Mrs. Brown to the courts on different occasions is what I go by. That's all I can go by.
Okay, fair enough. I'll move on to my next question. You've sort of touched on my next question, but maybe you can add some further clarity. What was the purpose for the additional various persons being involved in property purchase as opposed to John W. Swan? So in other words, if you had 10 lots, why wasn't John W. Swan's name on the 10 lots as opposed to 10 other people?
Well, the property was purchased by John Swan from John Augustus, and then it was put in the name of other people because those days it was very hard to borrow money, and you couldn't borrow very large sums of money those days. Keep in mind that time, and so in order for me to build houses on those properties, I needed to be able to borrow money. So instead of putting everything in my name, which the bank would not loan me all this money, I put it in different people's names so that we could borrow the money on their names, which people that were employed by me, and be able to borrow the money and either sell it off to somebody else or transfer it back to myself once the house was completed. And either we rented it or we sold it. And I did this throughout the whole island, many, many houses.
Yes, okay, so I think I understand that aspect. So just for further clarity, so although these persons who were your employees or agents as such, I use the word loosely, agents, not sales agents per se, these persons acquired financing in their own right?
No, I
helped them
to acquire it. I was the one looking for the mortgages to get it done.
Okay.
They were some of them were my salesmen, some of them were my contract. At one stage I had 18 contractors working for me.
Yes.
And they were all, these transactions were designed to take and produce the houses that people live in today.
So effectively, if I understand it correctly, it was sort of a shell game.
It wasn't a shell game at all. It was a transactional game that was accepted at the time. We had no devious methods at all. Shell is suggesting that it was a method of deviousness. There was nothing devious about it.
No, I didn't mean it in that context. I meant it in the context that there was a temporary arrangement which was initiated by you, sent to other people, and then subsequently reverted back to you. That's what I meant as far as a shell. Yeah. So you're saying the same thing. You're just saying transactional. That's so we have an understanding there. I accept that. My next question: if you were oblivious to any quote unquote conspiracy, would it be fair to say that you and your company were the major beneficiaries by your purchase and subsequent development of the Virgil property?
we were the beneficiaries of the purchase of the property from John Augustus.
No, I'm not talking about who it's from. I'm just,
Well,
what
sir,
I'm trying to do.
in the context, we must keep things in context. I bought the
Yes.
property from John Augustus, not from Levi Pearman and not from John Virgil. I bought it from John Augustus. I bought the property, and through various transactions, I benefited from it. That's true. You asked me a question, I'll give you an answer. It's true, I benefited from it.
Okay. By extension, it would be fair to say that the Virgil family had no benefit.
That's not my decision to make, sir, because if Mr. Virgil himself sold to Levi Pearman and got, as I understand, money went into his bank account, that's between Mr. Levi Pearman, Mr. Virgil, and Mr. Virgil's estate. It has nothing to do with me.
All right, okay. Next question. You have stated at the time of the subject property purchase that you were responsible for approximately 40% of Bermuda's development.
Over a 10-year
I
period.
presume that's, pardon?
75 to from 1965 to 1975.
Right. And I would presume that would be residential development. Yes.
Residential development.
Right. Okay. In your vast and varied experience, can you advise us as to the frequency at which discrepancies and the irregularities arose during your purchase and sales of property?
Sir, this is the most profound one I've ever come across. I've done hundreds of these transactions, and no one's accused me of taking property from them in an illegal or a dishonest way, or taking money from them in an illegal, dishonest way. When I owed bills or money, I paid it. And when I did transactions, I honored those transactions. And I always dealt through the due process or the legal process in getting things done.
What I'm trying to get from you is, if you did 100 transactions, are you saying that 1 out of 100 you would have?
If I did 100 transactions, chances are 1 out of 100 would have been, there would have been no discrepancies with the transactions.
That's extraordinary.
Well, it is extraordinary, but go check the public records. Go back through the public records. You will see no issues arising.
I'm sure the public records will reflect what you're saying.
So check it out. You will see that in my government public record, and you'll see that in my private public record.
Yes, certainly not my experience as a professional surveyor, but I digress. Would you characterize the transaction for, well, I guess you've already answered this question to some extent. So I'll withdraw the last question. That's it for me, Chair. Thank you very much.
Thank you.
Sir John.
Yes, Mr. Stovall, you've completed your questioning. Mr. Starling, do you have any questions?
Yes, I do. Thank you. Good afternoon, Sir John Swan.
Good afternoon, sir.
Got a few questions. I'll try to keep them succinct. Just going back to what Commissioner Stubble was referring to, the way that the property was transferred to your employees for mortgage financing and then transferred back to you. I understand that was standard practice at that time.
Yes, it was.
Would it be fair to say that is no longer standard practice today?
I'm not building now, so I'm not doing it, so I can't tell you whether it is.
Okay, fair enough. The employees that had the property transferred to them, I would assume that they consented and there was a contract of sale from you to them. Okay,
That's right.
Could you remind me what your relationship is or was to Russell Pearman?
I had no relationship other than I knew him. I think he was a member of Parliament at one stage, and he was a businessman, but not I don't even know who he worked, quite frankly with you.
Okay.
So I can't verify anything other than Russell Pearman as being Russell Pearman, who was Ron Hamilton, like so many other people were Ron Hamilton.
All right. I may have misread some of the evidence, so I just wanted to clarify while I had the opportunity. The reason I ask is because in your opening statement this morning, you noted that you had the property subdivided into 8 subdivisions. Is that correct?
It was sold to me as 8 lots.
Okay, so it had already been subdivided
It
to.
was sold to me as 8 lots.
Okay, thank you. That clarifies my misreading. My final question is, I understand you were the Minister of Home Affairs, the minister responsible for the police at the time when a police investigation into this matter was launched.
It was around that time in 1976 when I became Minister of Home Affairs. So the exact dates I can't give you, but I know that, you know, it was around that time. I was Minister of Marine and Ports. I was in government at the time. I was Minister of Marine and Ports in 76, and I also was became Minister of Home Affairs in 76.
Sure.
So I was really, in a sense, you know, part of my business being run by other people as I try to serve the government.
Yeah. Just recognizing the constitutional separation of police control between government house and the Bermuda Parliament, how would any potential conflict of interest have been handled at that point with you as the minister and the police investigating?
Well, the British government on matters of police matters is the responsibility, but you know the role of Home Affairs was a liaison between the police and the and government house and the government, right. And that practice continues on today, and because there were issues of establishment and issues of financing that needed to be done. After all, the Minister of Home Affairs put forward the budget for the police always. So the governor is responsible for security. In other words, the day-to-day policing of Bermuda is the responsibility of the governor under the supervision of the Commissioner of Police.
I'm just cognizant that some lay people may see that you were the minister responsible for police while a police investigation was going on. So I would just want to give you that.
Somewhere in that area. I don't recall the exact dates, quite frankly.
I just wanted to give you.
I was involved with government anyhow with matters. And I had slowly stepping away from my day-to-day affairs of government. As you know, when I became premier, I completely stepped away. But even in Home Affairs, I would say that except for circumstances, I was away from my business an awful lot because I wanted to give we had some real serious management problems in the country at the time. Sure. And I wanted to put the time into, as you know, to straighten them out, which I managed to do. And I couldn't do both jobs.
I just wanted to give you the opportunity to address anyone who might say that you may have had undue influence over an investigation.
No, I had no influence whatsoever over investigation. That was a matter for the police.
Thank you. That is all of my questions at this time. Thank you.
All right. Thank you very much, Mr. Starling. Counsel, that appears to be the last witness or the last person question, Sir John. I would ask you now to make any further comments.
Chairman, then I'll probably invite Mr. Hanson to proceed.
I was very comfortable because I thought it went towards his credibility because he's lying and he's hiding behind some BS.
Mr. Brown, you got a hot mic.
And Mr. Brown, those comments can have consequences.
I would take it that any conversation that was overheard was not intended to be included in the commission's.
If they're made, they're concluded.
Brown, are you willing to say that you have not intended to make any comment to this commission at that time?
That would be correct, Chair. Any comment that might have been heard in the last 5 minutes was not intended for for others.
And it should be struck. It should be struck from the record.
It would have been my mistake to have that comment made while the mic was open.
In that case, we'll have it struck from the record. Right. Council, would you now make any comment you wish to?
Yes, I just invite Mr. Hanson to proceed. As you choose.
Mr. Chairman, for Mr. Hanson proceeds, can we change locations because the battery in my iPad is going down and I need to plug it in somewhere? Can I have about 2 minutes to just relocate?
Mr. Pierman, Mr. Parent-Chief?
Chairman?
Yeah.
Mr. John relocate. Can you give him 2 minutes to relocate so he can get his battery up?
Oh, yeah, if that's the request.
That's all.
Yes. If our technicians would take note of that and make any necessary adjustments so John can relocate.
I think he's just moving so he can plug it in.
Yes, not a problem. We'll wait.
Back on. Hello?
Yeah.
Oh, yes. So John, you're now live once again. And Council, I think you were requesting that Mr. Hanson make any comment that he wished to. Is that correct?
That's correct, Chairman.
Thank you, Council. So I have no comments for Sir John, if that was the question. No questions from me for Sir John. And there's no witnesses from the bank, given there's no one there from 60 years ago. So I would just now, unless there's any witnesses, suggest we move to the party's closing.
And Chairman, well, through you, just to understand the position of the Bank of Butterfield is that there's nothing that they wish to advance at this time in terms of what has been suggested by the claimants. They don't wish to respond. They're just trying to understand that.
No, Council. So in closing, I'll obviously sum up the position. We don't have there's no witness available from Butterfield to provide evidence other than the written submissions and documents we've already been provided.
Okay.
So my question would be, if you wish to make any closing statements, you can do so now.
Is that to me, Chairman, or is that to Council?
Yes, Ms. Hanson.
I'm happy to make closing statements now, Chairman. Normally, the parties bringing it would commence their closing, and then we would follow in the normal course. If the Commission's view
I concur with Mr. Hanson.
To be backwards, that's for the Commission.
Yeah, Council, if you give us some guidance on that.
Yes, we could hear from the Browns if they wish to advance a statement in closing.
You're muted, Mr. Brown.
Yes, thank you. Chair, with your permission, my mother would like to make a few remarks by way of a closing comment, and so too would my brother George. Before he would like to make a 3-minute statement, and then I have a 5-6 minute statement to read. So with your permission, the three of us would like to contribute to the close. About 12 minutes between us.
Yes. Following the direction of council, you have the opportunity now to make your closing statements, and if you wish to segment them into 3 separate statements, then you can carry on, Mr. Brown, starting with Mrs. Barbara Brown.
Okay, if you just give me a moment to get her, my mother situated. She probably needs a minute just to get in front of the, to get in the chair, with your indulgence.
Yes, sir. You may carry on, Mr. Brown.
I'll just stay there. Watch out for the port. What's your foot? What's your foot? The last foot. There you go. Okay.
Okay, so Bobby, you're on, okay?
Maybe you could adjust the camera down. That's great. Thank you.
Yes, good afternoon, Mrs. Brown. If you wish to give your testimony now, you can continue.
Good afternoon, Mr. Pages and
Yes, madam.
commissioners. And commissioners
All parties present. All parties present.
and all parties present. Good evening, Mr. Harrison. Good
evening.
afternoon.
Good afternoon.
Good afternoon. I'd just like to say thank you, thank you, thank you. And to you, Mr. Pages, I'd also like to say thank you, thank you. And to the commissioners as well.
You're welcome, ma'am.
Thank you, thank you. Now, let me just say what I'd like to say. Sitting here this afternoon, it's a very painful feeling. And it's been a long journey. And I'm just hoping and praying that this is the end. I also want to thank my 2 sons, Charles and George, and also my son, Walton. And also like to say to my family and my many, many friends that's kept me on my feet. And thank God, thank you, everyone.
Yes, madam. Yes, thank you very much for your comments and testimony in front of this commission, madam. And I believe your next son wishes to give some testimony. He may do so now at this time.
Okay, come on, Bobby, real quick. So George could get there.
Now this one to make sure. So you can read it.
Yeah, George.
Good afternoon, everyone.
Mr. Bond, George,
Yes,
you may lead your testimony, sir. You're winding up.
Summation.
yes, thank you. Good afternoon. I would like to thank the Commission of Inquiry, the chairman and the panel members on the way they conducted a fair and balanced proceedings. In particular, I would like to thank Mr. Harrison, who has been a constant figure throughout. It has been a vision of many to have a commission of inquiry look into the historic losses of land in Bermuda. I can say that I'm very happy to know that the chains have finally been broken, and we have no doubt in our minds that justice will be served. I would like to thank my late brother, Walton Brown, who has given my family the strength, the courage, and the wisdom to not give up. It has always been our journey to seek justice for all who have been affected by systemic fraud and injustice. Today, in our new era of living, Bermuda's reputation has benefited from international business and has become a major center for international and offshore business in the world. Therefore, as I read our closing remarks, Bermuda's reputation is at stake to correct the wrong of the past, which was contrary to conscience, resulting in treating others unjustly. The institutions mentioned in our presentation from the very beginning, Appleby, Sperling and Kemp, Baker Butterfield, John Swan Limited, Cox and Wilkinson and/or David Wilkinson's estate must be held accountable and brought to justice. Throughout these proceedings, my brother Charles and I have diligently presented our case, and we are convinced that we have uncovered the fraud and have connected the dots to hold those accountable. In particular, the major players in this systemic scheme could not have engaged in their illegal and fraudulent behavior without those institutions mentioned, and who also were served adverse notices by this very commission. It must be stated that in every hour, there have been people who have had an excessive desire to accumulate money, power, prestige, and wealth at the expense of others. The major players mentioned acted less than honestly and enjoyed stacking it up in the face of the far less fortunate ones in the business world, and including my family. And that often meant cheating at the expense of people who had trusted the system, including my family. We say this is our day for the chains to come off, and we pray that a resolution can be recommended, or that some legal rule exists under which a theory or a claim can be made to find those culpable in a criminal matter. This is no longer a civil matter. Respectively, we ask this Commission of Inquiry to afford us the justice the beneficiaries and all of my family rightfully deserve. Thank you and bless your hearts.
Thank you for your submission, Mr. George Brown. We'll now hear from Mr. Charles Brown, I believe. You may give your testimony, sir.
Thank you, Mr. Chairman, and good afternoon, all again. So this is our summary remarks submitted to the Commission with regard to the historic losses of land. So in November 2020, a claim was presented to this Commission of Inquiry on behalf of the beneficiaries of John Augustus Alexander Virgil, that he was fraudulently dispossessed of his property in Spring Benny Sands. We have presented extensive and conclusive evidence of a plan to deceive our Uncle John, misrepresent his legal interests, engage in fraudulent activity behind his back to claim his property, cover up the behavior, and profit from this scheme. For decades, using money, muscle, and power, the architects of this plan and their associates have managed to avoid being held to account. There has been a systematic cover-up and obstruction of justice. This plan, engineered by Mr. Robert Modia from Appleby, Sperling and Kemp, with official misconduct, greed, and deceit at its core, used a network of relationships, ignorance, arrogance, and a callous disregard for the law in order to carry out the fraudulent activities. Some of the players were involved in planning this scheme, some involved in the execution, some involved in the cover-up, and some, like Robert Bermuda, involved in all of the above. As stated in our presentation and through sharing the evidence, there are two gatekeeper transactions at the root of this matter. We have shown that these two transactions were not rooted in legal activity. In fact, both are rooted in fraud and deceit and are at the heart of this land grab. No legal documentation was presented by any named party to this fraud to challenge that aspect of our claim. No sales agreement and no legal conveyance. As we summarize our position, we remind the commission that the beneficiaries have held the title deeds to this property since 1972, and they have been presented to the commission as evidence. These cover the period 1885 up to today. So on behalf of the beneficiaries of John Augustus Alexander Virgil, we stand by our claim that Robert Bermuda from Appleby, Sperling, and Kemp, now Appleby, engineered and facilitated this fraudulent scheme that involved lawyers, including family lawyer Eric Jones, bankers, and real estate agents, to lay claim to the property and to then transfer or sell it to others, including Eric Jones's wife, Elizabeth. Bermuda worked in partnership with Eric Jones and John Alfred Virgil from Somerset. He drew up a covenant in 1962 between these three parties regarding the sale and future use of the property. Bermuda documents the supposed sale of land from John Alfred Virgil, the imposter, to Eric Jones, the Virgil family lawyer. At the time, John Alfred Virgil, the imposter, earned none of this land he was claiming to earn and sell to Eric Jones. Bermuda set them up. And Mr. Carlton Adams said Bermuda made a mistake when he wrote to John Alfred Virgil, the imposter from Somerset, in 1962. Adams was trying to prove that Sir John and others did no wrong. This was similar to the role that Bermuda played when he wrote the Banks report into this matter back in 1978. Mr. David Wilkinson, he asserts that John Augustus Alexander Virgil conveyed the southern portion of his land to Eric Jones in January 24th, 1962, and that he prepared and held the conveyance for this transaction. Several conveyances on this property were drawn up by Eric Jones between himself and John Alfred Virgil prior to Jones claiming ownership in 1962. John Alfred Virgil earned none of this land, so why was he even in the picture? John Alfred was, as we understand it, a jealous first cousin with the same name. How convenient. 7 years later, in 1969, after the southern portion was inappropriately claimed by Eric Jones, Mr. David Wilkinson of Cox and Wilkinson fraudulently advised the Registrar General's office that his office drafted and held a conveyance between John Augustus Alexander Virgil and Eric Jones from January 1962. The Bank Butterfield later reported after their investigation in 1978 that the documents supporting this transaction are missing. Still, we maintain today that the property is fraudulently claimed. This is the essence of the activity surrounding the southern portion. Mr. Robert Bermuda was also central to the 1969 transaction for the northern portion that involved David Wilkinson, law firm Cox and Wilkinson, Wilkinson's client, Russell Levi Perriman, and John W. Swan. Russell Pearman was the aggressive real estate agent. In fact, he was agent extraordinaire. He was John Swan's buddy and business associate. Russell Pearman applied to the Central Planning Authority in March of 1968 to subdivide the northern portion. He did not earn the property, neither was he acting for the earner. He was fraudulently misrepresenting his ownership of the property. He later had documents forged to change the dates on the documents that he had submitted to planning. Ms. Brenda Petty, the handwriting expert witness, confirmed that Mr. Pearman's submission to the Central Planning Authority was altered by hand. Russell Pearman, John Swan, and Emmanuel Augustus, they met on site in December 1968 to discuss the January 1969 transaction. In April 1969, lawyers Motier and Wilkinson, they claimed that John Augustus Alexander Virgil conveyed the northern portion of his property to Russell Pearman, and that on the same day, it was conveyed to Emmanuel Augustus. And a year later, in 1970, John Swan then claimed title. Swan then set about a flurry of conveyances within days with his staff and associates based on the fraudulent application to the planning department by Russell Pearman to subdivide the property into 8 lots. And Robert Motier was key and hands-on to both of these fraudulent transactions. When invited to address this claim, Mr. John Swan presented documents to the commission from 1970 that purported to represent a legal claim to the northern portion of the property. This was based on a sale from Emmanuel Augustus. This 1970 transaction is directly related to the 1969 transactions that Ms. Brenda Petty, the handwriting expert, discredited them on the basis of fraudulent signatures. This fraudulent transaction from 1969 with John Swan's client, Emmanuel Augustus, is at the root of the transaction with John Swan in 1970. Incidentally, Ms. Petty was not challenged by anyone from the other side of our claim. 1969 sales agreement and the 1969 conveyance of forgeries, that was not questioned by any of the counsel from other sides on the authenticity of these 1969 signatures to support his legal claim to the property in 1970. We also remind the commission that when John W. Swan was interviewed by the police during the 1975 investigation, he refused to cooperate and provide the sales agreement or the conveyance from the 1969 that would exonerate him. Instead, Mr. Swan advised the police investigators that he could not find the relevant sales agreement or conveyance to support his legal claim to ownership of the northern property. John Swan also reported to the commission that this matter was put before the courts on 5 previous occasions. While that may be somewhat correct, what John Swan and his learned counsel chose to carefully avoid telling you is that these matters of old are all civil matters. Importantly, this current matter, while similar, is all about criminal fraud. This matter has never been examined from a criminal fraud perspective. It has never had an expert in handwriting analysis available to assist with this matter or to confirm what we believe for decades about those signatures. Never has an independent commission of inquiry been empowered to investigate this matter. When the Bank of Butterfield had the opportunity to challenge our claim about the 2 transactions, Bermuda's First Bank presented virtually nothing. The bank did not support, defend, or materially rely on their 1978 investigative report into this matter. The bank reported that the indenture to support Eric Jones's 1962 claim, they said that indenture is missing. The bank was silent on their responsibilities as executor of the will of John Augustus Alexander Virgil under Section 50 of the Trustees Act of 1876. And the bank is not able to produce any bank account records to support any claim of payment to John Augustus Alexander Virgil for any sale of his land. The two lawyers involved in the northern portion offer conflicting stories about how this land was paid for. Mr. Modia claims the payment was in cash. Mr. Wilkerson claims the payment was via check. The engineer, Mr. Modia, he was tasked with authoring this bank investigative report. And the purpose of the report was to prove a false narrative that John Augustus Alexander Virgil earned no land at the time of his death. This was a huge conflict of interest. When questioning our claim, the bank referred to one paragraph in their report and offered no contextual or factual reference to this content. This paragraph, 50, was not linked to any other evidence by the bank. Apparently, the bank believed that the report from Mr. Carlton Adams was the spine of the matter. We maintain that the report from Mr. Adams lacks credibility, as he himself, Mr. Adams, admitted that its value was greatly diminished as a result of a series of errors in his submission. Representatives of Appleby and the estate of Robert H. Modia declined the invitation to respond to our claim. They declined to address the lead role that Mr. Modia played in this illegal land grab. There was no representation to this commission from Appleby to challenge our claim about them as we presented in November 2020. Appleby played a major role in this. They provided legal services to several parties to the matter, and Modia was hands-on with both of the fraudulent transactions involving the southern and the northern portions. They were counsel to John Augustus Alexander Virgil and John Alfred Virgil. Appleby drafted the will for John Augustus Alexander Virgil, and they held his deeds. Appleby was representing the Bank of Butterfield, and they drafted the report that was to investigate the title of the property. So Appleby they were all over this. A representative from the estate of the imposter, John Alfred Virgil from Somerset, also appeared before the commission. The representative did not present any material to the commission or ask any questions of the beneficiaries. Instead, the representative chose to use the undervalued submission from Mr. Carlton Adams to claim that John Alfred Virgil from Somerset did no wrong. John Alfred was on the team with Robert Modia and Eric and posed himself as owner of the finances with Eric Jones, despite having no legal title. He should not have even been in the frame. He earned none of this land. Appleby and the Bank of Butterfield, through the work of Modia, are linked to both of these fraudulent transactions. The residents of the Spring Benny community, they have declined invitations over the years to present their deeds to bring clarity and some measure of resolution to this matter. Also, a caveat was filed with the Supreme Court in 2005 to challenge the legal transfer of a family property on this land. This caveat remains unchallenged today. Throughout this tireless pursuit of justice, the beneficiaries, Mrs. Barbara Brown in particular, faced threats, intimidation, and economic stress and strife from the named parties. This has strengthened their resolve. And although it is sad that some of the beneficiaries have passed on, the surviving beneficiaries are standing firm. And it is our expectation that this commission, in furtherance of its mandate, does cause the matter to be fairly adjudicated. The beneficiaries of John Augustus Alexander Virgil remain steadfast in their claim that the land bequeathed to them was inappropriately and fraudulently taken from their uncle. They are still here today addressing you through my voice and my brother's voice to seek justice and compensation for this matter and to hold the perpetrators of this scheme to account. Mr. Chairman, as I close, I would like to say a few thank yous. Thank you to our family, our extended family and friends that have shown consistent support at these hearings and away from these hearings. Many thanks to the government of Bermuda for establishing and moving forward with this commission. And a special thank you to the commission members for serving Bermuda in this manner, and at times serving under challenging circumstances. Nevertheless, you are still here, and for that, we say thank you. We also wish to acknowledge and say thank you to the Commission's technical and administrative support teams. Thank you for your good work under bumpy circumstances. And on behalf of my mother and other beneficiaries, we say thank you to Commission Counsel, Mr. Harrison. Sir, thank you for your service.
Yes, indeed.
Thank you, Commissioners, and good day.
Thank you very much, Mr. Brown, for your comments of the Commission of Inquiry and its support unit. We appreciate your evidence, and we stand to do whatever's appropriate in the circumstances.
Certainly.
Thank you very much, sir.
What are the next steps in this process? If you could speak to that at this time.
Yes, I'll now revert to counsel, and he will continue to advise you. Nevertheless, counsel, if you make any closing comment now.
Thank you. Chairman, my understanding of the order, and I yield to any comments that may be offered by counsel present, is that the order to be followed hereon, and if I use in the strict sense, whether persons presented any evidence at all, I would say that the next order is that it is for Mr. Hanson and Miss Virgil to present. I will then present, and last, Mr. White. That's my understanding of the order that should follow in terms of calling of witnesses in that regard. That's my understanding. I don't know if there's any comment, but following now is either Miss Virgil or Mr. Hanson, whatever order I will follow, and then last, Mr. White.
Yes, following your directive, counsel, I'll now call on Ms. Virgil first of all.
And remember, there was some special. There was a request that you had considered on the last occasion in terms of hearing from her. So if that could be facilitated.
Yes.
Mr. Chairman, if I went first then, and then we can change to the other camera, that might help everyone feel more comfortable.
Yes, we can do that. In that case, we'll reverse the order. We'll hear from Mr. Hanson first of all, and then we can hear from Mr. White, and then lastly from Ms. Virgil, and that would facilitate not having to change the cameras. Thank you. So, Mr. Hanson, we can hear from you now.
Thank you, Mr. Chairman. As you're all aware, I act for the Bank of Butterfield & Son Limited, which is the parent of Butterfield Trust Bermuda Limited. which was formerly the Bank of Butterfield Executor and Trustee Company Limited. So as I said, 4 or 5 days ago when we started, if I'm referring to Butterfield or bank, I'm referring, of course, to the executor and trustee company, the one in question at the time. You've heard a lot and digested a lot, I imagine, over the past 4 or 5 days, ably run by counsel for the Commission. But I think it's fair to say that we jumped around multiple allegations and evidence, new and old, with some degree of speed. So I think it's worth narrowing down the issues with respect to Butterfield and to focus the minds of the Commission on that element for these submissions. So just to recap, without going over all rote, Mr. John Augustus Alexander Virgil named Butterfield as the executor of his estate in his last will of a testament in May 1964, almost 60 years ago. Unfortunately, on the 17th of January 1972, Mr. Virgil died, and his nieces and nephews were named as the beneficiaries of that estate, with probate being granted on the 24th of March 1972. Now, the primary allegations, from what I gathered from evidence both written and submitted in respect of the claim against Butterfield, just Butterfield, was that in its capacity as executor, it failed in its fiduciary obligations to the beneficiaries by effectively not declaring the property we've all been talking about in Sandys Parish as part of the estate, and then failing to distribute that property to the beneficiaries of the will in accordance with the terms of the will. And then added into that was a conspiracy or an agreement of some sort between Appleby, Spurney and Kemp, which is now Appleby, of course, to prepare a report where Appleby were conflicted to do so, and Butterfield should have not allowed that to happen. Now, I said a moment ago that Butterfield unfortunately could not send anyone to give actual evidence. There's no one present, no one works there now who was there then. And that's not, of course, not even withstanding its various corporate structural changes over the decades. But alluding to Mr. Brown's point, Butterfield still wished to take part, and provided that all the documents it had. What, of course, has transpired and become abundantly clear throughout this process is that Mr. Brown and the beneficiaries were excellent at retaining records. And we actually have a very detailed bundle of documents, relevant documents, which is, of course, what we've all been working through. So turning to the allegations themselves, let's first deal with the property side, and I'll split it very briefly into a legal position and then the factual position. So the legal position, I would respectfully submit, is that prior to the 1st of September 1974, estates or matters such as this would have been governed by the Trustee Act of 1876. And real property, i.e. what we're talking about, the Sandys estate, did not form part of an estate for the purposes of administration prior to coming into force of the Stamp Duties Act of 1976, i.e. a few years after probate was granted. So a pre-1974 Act executor had no statutory obligation to treat real property of a deceased as part of the estate. So before we even get to the facts of the matter, which I will get to, my position is, on behalf of Butterfield, there wasn't a duty to distribute that property anyway at the time. Now, moving on to the claim. So the other element of it is when Butterfield became the executor of the will. And I think this is sort of perhaps a bit of a red herring, but I think we should address it, as Mr. Brown was emphatic that appointment as executor crystallized at the date of the will in 1964. We, of course, say that no, the date was the date of Mr. Virgil's death in 1972, because there wasn't an estate prior to that. So it's at 1972 that the executor would start to implement its duties. It was not the executor, Butterfield, prior to Mr. Virgil's death, because there wasn't an estate to be administered. So, moving on. Now, even if the legal position is incorrect, the second side of this and the factual position is, even if Butterfield did have some obligation to deal with the property itself was sold by Mr. Virgil prior to his death. Now, I appreciate this is where views diverge. So in urging the commission to conclude that Mr. Virgil did own the property, they being Mr. Brown, ably presented, and the beneficiaries relied heavily on the report of Bermuda Caribbean consultants. And we've been through that report, I think 5 or 6 times, so I don't think we need to draw back to it. But ultimately, you will all recall, I hope, that they said there was no record of disposal of the property. The converse position to that was the Appleby report, commissioned by Butterfield on the 30th of October, I think it was 78. They concluded differently, saying there was a conveyance. So we have a dispute of fact between the two reports. Now, the commission, I hope, recalls, and I did watch it again this morning to remind myself of exactly what was said. But when I was cross-examining Mr. Brown, he conceded that it was his understanding that the conveyance to Pearman in 1969, this is the conveyance from John Augustus Alexander Virgil to Mr. Russell Levi Pearman, that critical conveyance existed at the time, i.e. that is what the executor and the banks had, the bank and the lawyers and those parties involved had in front of them. That was conceded by Mr. Brown. And it is clear from the documents that was provided by Mr. Brown and the beneficiaries, as well as being found elsewhere through the registry, etc. So I don't think there can be any realistic factual dispute that at the time, that conveyance, that piece of paper showing the conveyance was in front of the executor or Butterfield, and that was what they were working off when asked questions on it. Okay, so I think it's really important for the commission in the midst of all the maelstrom of evidence and quite understandable emotive content, the reality was at the time, that was the document that was present. So Butterfield's responsibility was to administer the estate as it existed. And for those reasons, as confirmed by the parish vestry records and conceded, there was a document that showed that Mr. Virgil was no longer the owner of the property in question. So the decision not to distribute the property was not negligent, it was correct. That's the reality. But what is different now, and I noticed Mr. Stovall's questions with interest, because of course, what has transpired through the course of the evidence we have all listened to now is we now have a report, albeit 50 years on or so, that questions, an expert report that questions the validity of the signature on that conveyance. And a probability, I think was the exact phrase. And we don't, for my purposes, don't need to get into how that was caveated within the report. Perhaps Mr. White will do so. He raised it in cross yesterday. But we'll use the word now for probability that conveyance was, that signature on the conveyance was a potential forgery. Now, in normal circumstances, we would have Mr. Pearman's representatives here, either producing their own expert or cross-examining to an extent that issue to try and get more meat onto that and to give that a more substance and credibility. Not that I'm saying the expert in any way was not credible. Quite to the contrary, I thought she came across very well. Okay, but let's take that to a side. Let's assume the expert didn't give a caveat. Let's assume the expert said there was a 100% chance that that signature was forged. Okay, that's hypothetical. It's not a concession, counsel. Hypothetical question. Well, that has been discovered in 2021. Butterfield had no idea of that expert's opinion 50 years ago. There was no handwriting expert produced to them in the 70s to say, look, this was forged. You need to look into this. We needed an expert to get to that conclusion. The police report never talked about Virgil's signature. There was some query on another signature, but the police report, I think, said to the contrary, that the signatures were similar. So whilst I understand the questions from the commissioners in respect of that issue, and indeed it deserves some investigation respectfully, it's not in any way relevant to Butterfield's duties as the executor at the time. You know, never mind a fire, there wasn't smoke, there wasn't even kindling or wood or matches to which light it. There was simply no connection. The executor had the conveyance in front of them. There was no reason whatsoever to assume that there was a fraudulent signature by Virgil at the time. And there's been no evidence to show at the time that that was written and submitted clearly or understandably to Butterfield at the time. And dealing quickly with the conflict claim. So in essence, I think Mr. Brown wants to discount the Appleby report. And I know we have evidence about the conveyance from other sources, but I still want to deal with this point. Insofar as that the author of that report was also involved in the will of Mr. Virgil. And Butterfield, you know, nefariously decided to instruct Appleby to do so. Now, obviously, we remember the main area of contention about that conveyance, I think, is now established in that there was a document which had the conveyance on it. So that's fine. So in some ways, this becomes irrelevant. However, what didn't come through very clearly is that I don't think there's ever been an argument that the will was drafted by Mr. Moiter in 1964, senior counsel at Appleby. But there is a difference of opinion, if not a difference of fact, that Mr. Moiter didn't draft the report in 1978, 14 years later. That's signed by NAO, which is Mr. Neil Orman, a different attorney. Now, this, again, when you're looking at something so far back in time, you sometimes converge dates to make it easier to understand. This was 14 years later. You know, that's a career for some lawyers, right? So, you know, it is a small island. You know, the issue of conflicts is something we deal with on a regular basis. Absolutely, it is an issue. In fact, I understand the Commission itself often grapples with the issue of conflict and who's involved in what and when. It's a difficult thing in Bermuda on any small island where there's a lot of transactions and unfortunately a lot of lawyers, right? That is the way it is. But it's not on the client to extinguish the duty of conflict. That's for the attorney to confirm. Now, Appleby, unfortunately, aren't here to say what processes they carried out or what the context of their instructions were or anything else of that nature. We don't have that, unfortunately. But it must be assumed, if Appleby would have considered the fact that Mr. Moiter assisted in 1964, that it did not think there was a conflict in providing a report to Butterfield in connection with the estate. The Commission should really look at that will. It makes a broad gift of all real and personal property to the beneficiaries. There is no specific mention of this property that we are talking about in the will. And then the other point on that report is it was commissioned at the request of the beneficiaries. That's what it says through the documents and the evidence given, for the express purpose of investigating their claim in respect of the title. So whilst beneficiaries may object to the conclusions, their recourse were the various Supreme Court actions they took. But it cannot be, you cannot taint Butterfield with that to say that Butterfield somehow were involved in a conflict of interest point. It wasn't Butterfield's issue to deal with. It was asked to investigate title. It did so through, obviously, I assume, some expense to investigate title. The documents that were then presented in that report are the ones we're using right now, with the difference being there appears that there might be some forged signatures on it. But at that time, the interests of Butterfield and the beneficiaries were aligned. But Butterfield wanted to get to the right position. There's no upside for Butterfield in whatever conspiracy the Browns think they were involved in. So the bank, has obvious empathy for the position that the Browns are now in, but it has nothing to do with the bank as an executor or Butterfield as an executor at the time these actions took place. So, in conclusion, one cannot say that opportunities have not been given in this commission. I think it's evident from the thanks that was given by the Browns to the commission and to the commission's counsel. This has been ably managed by the commission. Counsel for the commission was articulate and patient. We had some unusual situations arise. We had an example where the commission's counsel was cross-examining an appointed investigator by the commission and then doing so again. We had situations where witnesses were discussing evidence with each other whilst giving evidence. We had allowances of fraud being raised without specific evidence, something that couldn't be done in court. Amongst all these...
I'm sorry, I don't mean to stop. You said witnesses discussing with matters. I'm not aware of that. You just said witnesses discussing with each other.
Yes, so during examination and re-examination of the Browns, for example, there was communication between Mr. Brown and his mother, or Mr. Mother and Miss Brown. I wasn't criticizing it in a way. I was just emphasizing that there was a flexibility to proceed.
Oh, I thought you were saying that I had contact with them or something like that. Oh, okay.
No, sorry. And I don't mean, and I'm not saying that to criticize the Browns as lay people for not understanding that obviously on the stand, you shouldn't be conferring and helping someone with their evidence.
Okay.
The point I'm getting to is that it was a flexible process and assumedly flexible on the commission's behest to get to the truth. Okay, so that was the point I was driving at there. But through all of that and through all of that context, the allegations against Butterfield do not demonstrate to any degree at all that Butterfield made any decisions or acted improperly in any way with the information they had at the time, which caused the beneficiaries to suffer a loss of land. So in the circumstances, my respectful submission should be, the commission should make no adverse findings as against Butterfield. Thank you very much, commission and council, for your time. I would also echo Mr. Brown's thanks to the secretary and the technical team who have been very good in trying circumstances. And with that, I close my submissions. Thank you.
Thank you.
Thank you very much, Councillor Hanson. We'll now revert to Mr. Kim White, counsel for Sir John Swan.
So I'm going last, as with Mr.
You're going to go
after Mr. Harrison. What you're going to do now is turn the Facebook off and stop as agreed by for the application that was made to you before.
And then you wish to come after the lady then?
Yeah, the lady, then Mr. Harrison, then myself.
Yes, Chairman, just in the normal order that would follow in terms of witnesses being called, and seeing that I had gone before, I certainly would yield to counsel last, but because no witnesses were called by Mr. Hanson or by Ms. Virgil, they would go before.
So we'll now hear Ms. Virgil.